A solicitor's reputation is valuable, and damage to this reputation can prove costly. In this program, Alyssa Baxter, General Counsel at Law Cover, and Alex Haslam, Principal at Gilchrist Connell, examine the underlying causes of claims in the area of defamation, why solicitors are at risk, and the precautions that they can take to control the risk within their practice.
Thanks for joining us to talk about defamation. At Law Cover, we've seen a steady stream of claims against solicitors for defamation allegations, either by the client, most often by somebody else alleging that a solicitor has defamed them. And so I wanted to have a chat with you today about why we might be seeing those claims arising and what solicitors can do to avoid those kinds of claims in the future. So I'll just give you an outline. Most of the things that I'm going to talk about today are not reported cases because most of the time they don't go to court. But I'll just give you an example of a case that we did have. A solicitor, on instructions from her client, wrote to a school teacher alleging that her client had been sexually harassed at school, actually wrote that to the principal of the school, making those allegations saying, I'm instructed that my client was harassed by so-and-so teacher, and then sent that letter to the school principal as was the proper thing to do, but sent it by fax. And the fax machine for the school was in the admin area, and quite a few people saw that letter before it got to the school principal's desk. So I guess there's a couple of things that arise out of that. The first is that when that claim was first made, the solicitor came to Law Cover and said, surely I can't have defamed anyone, I was just acting on instructions.
Well, that might well be right, and I hate to be the solicitor who says it really depends on the circumstances, but I'm going to be that person. The reason for that is that, yes, as solicitors, we are agents or representatives of our clients, we're their mouthpiece. And if we're acting on instructions, then there is a possibility that we might have a full defence to any defamatory imputations that are contained in any letter that we send under Section 32 of the Defamation Act, which is headed innocent dissemination. And that provides that where you are, in essence, passing on publication by somebody else, in this case, the publication may well be the instructions that you got from your client, that you aren't necessarily liable for the imputations contained within your letter or email or whatever the communication is. However, as lawyers, we have an obligation, indeed that's why we're retained, to provide some legal advice to our clients on their factual instructions. And if the content of the letter overstates something our client has told us or puts a spin on it that is not entirely in accordance with our instructions, then it may well be that that defence is not available to us. It really does depend on the circumstances of the letter, because defamation is a cause of action that is based entirely on words. So if our words are not entirely accurate, insofar as they are completely true to what has been conveyed to us by a client, then we may well be open up for a claim for defamation.
What about the fact that the letter went to people it wasn't intended to go to? Or it might have been seen by people who weren't intended to see it?
Well, that's unfortunate, but that doesn't excuse a person from publishing a document for the purposes of defamation. So in this case, yes, it was intended for the school principal, but what happened was it was sent by fax machine, an open fax machine, and anybody could have seen it. So that is a publication for the purposes of the Defamation Act, and perhaps we can talk about that a bit later. But in this case, it doesn't really matter. It was intended for one person, seen by another. That's all you need in terms of a claim for defamation. What they could have done to avoid that is either hand deliver it. Mm-hmm. I mean, that's very archaic, but when you're dealing with very serious allegations, as they were in this case, perhaps that would be the best option. Mark it private and confidential for the eyes of the school principal only. Mm-hmm. Find out whether the fax machine was indeed an open fax machine, as in this case.
And or then, where it's located.
Yeah, absolutely. Sure. Whether it's call the principal and say, I've got a very significant communication to send you. Where is the best place I can send this so that only you will see it?
And these days you could have emailed it.
We could have emailed it, but again, where you have a school principal, usually his administrative assistant may have access to that, and if, in this case, she saw it, that would still be a publication for the purposes of the Defamation Act. Even though if you seal an envelope and mark it private and confidential, there are two conflicting authorities that suggest they conflict, because one is a very old case where someone sent a letter addressed to a recipient and sealed it with wax, and somebody else opened it, and the court held that there was no defamation because the person who read it, it was not intended for that purpose, for that person, and the sender had taken all reasonable steps to try to avoid anybody else other than the intended recipient.
So keeping something sealed is quite a good way to stop. Lets people know you shouldn't open this.
Potentially, though, the conflicting authority is where a letter was sent to a husband and the wife opened it. And the court held, well, you should know that if you send something to a husband, that the wife might well open it. And therefore there's a defamation because it's published to her. So it's difficult to know what to do in the circumstances, but I think just approaching the intended recipient to say, where can I send this to, where only you will be able to see it,
Sure.
is a good start.
Well, that is, and it's a step that a solicitor can take, because solicitors take considered steps when they're sending off serious allegations. So I guess it's not too much of a stretch to say make a phone call first, or hand deliver something, get it sent by courier, make sure it only falls into that person's hands.
Correct. I mean, we have so many different ways of communicating these days, and if you're aware of the risk, you can certainly take precautions.
Sure. So we have seen in the last 5 years or so an uptick in the number of defamation claims that are being brought against solicitors. And I have a view about why that might be. Part of that, I think, is that solicitors tend to have a very adversarial mindset, and so the first thing they think about is, I can litigate this, when there is high emotion involved in something. What do you think? Why do you think we're seeing an uptick?
Well, I certainly agree with that, particularly litigation solicitors. We're bred to...
As you and I are.
Indeed. We're bred to fight, in essence. That's our daily job.
No, we don't.
But I think the main reason really is that we're now in an age where there are so many different avenues by which we can publish material, and we can publish it at such great speeds that there's a real lack of consideration taken when publishing material. I mean, a publication, for the purposes of the Defamation Act, is a communication by one person to at least one other person, other than the person about whom the statement is made. So it can be spoken, it can be written, it can be on television, but it can be anything, really. It can be a facial expression, a photograph. But in terms of solicitors, what have we got now? We've obviously got the traditional letter, fax, I mean, not so much these days, email, certainly. It's an instant communication. Got solicitors writing blogs, social media posts.
Websites.
Absolutely, their websites, and a lot of solicitors do post
We'll talk about that in a minute.
commentary on their websites. But the internet is something that people feel that, look, I have a thought in my head, I'm going to publish it. Everybody needs to hear it. I mean, we're lawyers. I mean, a lot of us, not me, of course, have significant egos and feel that our views are very important and people need to hear them. I mean, traditionally, publications used to be television or newspaper.
Yeah, or magazines.
Absolutely.
Which take a month to come out, so you can think hard before you press print.
And what happens in a magazine is an author will write a piece, it will be edited by somebody else, it will probably go back for further revision, so there is a process. And if in the first instance a draft is very heated, the editor will likely take the heat out of it with an eye for ascertaining their own risk profile. And even if you were the editor and you drafted a piece, you'd draft it and then you'd look at it again and again and again. And that's traditionally how it used to be with lawyers as well. When we used to send letters, what would happen is it would usually be dictated. And so you'd dictate it, and even if you were heated up as to responding to a piece of correspondence and you drafted something in anger, it would go away, be dictated, come back maybe later that day, maybe the next day, and then you'd look at it with slightly cooler eyes and think, well, I can't be saying this. But nowadays, emails come in, they're responded to immediately.
And you can CC someone. You can CC someone straight away and it takes no time at all.
Absolutely. And we often do CC people into it. It's often a group conversation that we're having. And we're adept at formulating our views pretty quickly as solicitors, so we can turn something around pretty quickly. It's this lack of process that we have now that I think is causing a lot of an increase in the claims. And if you publish something, say by a blog or on your website, it's very difficult to take it down.
Yeah.
Even if you want to seek to retract it, it's usually there forever and someone can find it.
Yep.
I suspect that's why you're probably seeing an uptake these days.
Right. And we are actually seeing some claims or notifications in relation to publications that are made on websites. And it is an ordinary part of a solicitor's practice now to put commentaries about cases or commentaries about current affairs onto a website. So let's just talk a little bit about how solicitors can do that well and how they can do it badly. So I'll give you an example, a real life example. One of our insureds notified he had written, actually it wasn't a case he was involved in, it was just something he thought was interesting. He'd written a commentary about a workplace relations case, and the person who was named in that case, not his client, not anybody that he knew, she alleged that he had defamed her by repeating what had been said in the court proceedings. Is it possible to defame someone by repeating court proceedings?
Not if you repeat them strictly. I mean, there are statutory defences under the Defamation Act for publishing public statements or fair reporting, and they're under sections 28 and 29 of the Defamation Act. And the defences will be made out if the defendant can prove that the matter published was either a public document or was a fair report of proceedings that are of a public concern.
What's a fair report?
Well, really, it's something that doesn't go further than what is said. I mean, it doesn't mean that you have to quote verbatim, although I would strongly suggest that if you're reporting on something that, say, witness statements or witness evidence in court, I would certainly quote it. And the reason for that is usually that the words themselves convey the strongest meaning that you're trying to report on. That's why you're reporting on it in the first place. You've obviously read or heard something that you
thought
think
it was interesting.
Absolutely. So why not use the words themselves? Because if you use the words themselves, you can't be criticised.
Right.
You attribute them to wherever they've come from, and you would have a defence of fair reporting or public statement. If you go a little bit further, though, that's where you get into problems.
Or you paraphrase.
Well, if you paraphrase, it can start leading to difficulties. It depends, obviously, how you paraphrase it. I mean, if the paraphrasing conveys the same meaning as what was said, then I think you're all right. But often what we do is put a legal spin on it.
Yeah.
As lawyers, you'd say, well, this might be so-and-so cause of action, or this is a breach of this particular statutory provision, whereas that might not be apparent to the layperson from what was actually said.
Right.
So really, what my suggestion would be just to write it quite vanilla, as it were, quote where possible, and just leave it at that, because the words will usually speak for themselves.
Sure. Okay, so we see claims come into law cover alleging defamation, and the way that normally comes in is by a solicitor receiving a concerns notice, which is usually just a letter, and they send that in to us. And that's quite different from how other claims or how other causes of action are started. So can you just talk a little bit about what's in a concerns notice, why we have them, and what are the implications of dealing with them quickly?
Yes, well, a concerns notice is in essence, a letter of demand, but it's provided for under Section 14 of the Defamation Act. It doesn't mean that you have to write a concerns notice before you issue defamation proceedings, but generally most people do. And a concerns notice is where an aggrieved person will write to the alleged publisher to say, look, these are the details of what's been said and the alleged imputations that arise from what has been said.
So that's different from the words that were actually said.
Yes, an imputation is what can be derived from a statement.
Right.
How you can do that, it may be apparent from the words themselves,
Yep.
or it may be something that is the natural meaning of what was said. So I could say something to you, and there'd be no defamatory imputations in it whatsoever, but I could say the same thing to somebody else, and there could be defamatory imputations for whatever reason. But what a concerns notice does is say, I've been aggrieved by what you've said, and these are the imputations that flow from what you've said, and this is how I want you to make amends.
Okay. And so what steps should a solicitor take if they get a concerns notice?
Well, they can do three things. One, they can do nothing. If you feel that you actually haven't defamed someone, then there's no requirement under the Defamation Act for you to actually respond. You might just sit and wait.
Because you didn't do the thing that's been alleged?
Correct. If you do that and the person is serious in their view that they've been defamed, they may well then issue defamation proceedings.
Sure.
You can request more information. Often concerns notices are a little bit light on in terms of detail. Mm-hmm. And detail is key in defamation because what you need to demonstrate is that particular words have particular meanings. So often concerns notice will say, well, on this date you wrote these particular words and I feel that they're defamatory and I want you to make compensation to me. What that misses out is, well, all right, what are the imputations that flow from those words? How have they damaged your reputation? Mm-hmm. Key issues in defamation matters. So what you can do is you can write back and say, your letter is deficient in terms of particulars. Provide me further particulars. And if the aggrieved person doesn't respond and provide those particulars within 14 days, the original letter is deemed not to be a concerns notice.
Right.
The third thing you can do, and this is the real benefit of the concerns notice process, is that if you read the initial concerns notice and think, well, actually, I probably have said something here that is defamatory or might be considered defamatory, it gives you the opportunity to make amends. You can...
do you have to pay money?
You don't have to pay money. So an offer to make amends is provided for under the Defamation Act, and it will usually include a requirement for an apology.
Can you just take it back? Can you say, sorry, I shouldn't have said that?
You can retract, and that may well be an acceptable offer. An offer to make amends usually requires you to include an apology and a retraction.
Published to the people you first published it to?
You can make an apology to the person directly. You can offer a retraction. The retraction will usually need to be a public retraction. Mm-hmm. The apology doesn't necessarily need to be doesn't need to be published to the people to whom it was originally published. However, a retraction usually will come with an apology. You don't need to make payment, but often offers to amend do include a payment. Mm-hmm. An offer to make a payment. If that offer's not accepted and the aggrieved person then issues proceedings, it operates as a defence. An offer to make amends operates as a defence. It's sort of like an offer of compromise in that if you make an offer of compromise in general civil proceedings and the plaintiff doesn't get more than the amount that you've offered, you can get some cost protection. Mm-hmm. Here it operates as a full defence, that if you were to issue proceedings and someone had made an offer to make amends that included terms that you don't better in the defamation proceedings, you have a full defence.
To say it wasn't defamatory,
yes,
because I've said I'd take it back.
Absolutely, because defamation is based a lot on reputational damage. Mm. And if you can take the sting out of that initial reputational damage by apologising, retracting, then the court will say, well, your reputational damage is nominal, to say the least, so you have a defence. So it's a good process if you feel that you've actually done something wrong or something that you feel might be considered wrong, to try and nip it in the bud.
Sure. So so that's one defence. What are the other defences? So if there are proceedings brought against a solicitor, I know there are some very technical defences in the defamation area. Can you just outline what those are?
Well, I've previously referred to fair comment and publication of public statements. They're a defence. Truth. If what you said is true or substantially true, then you have a defence, because a key tenet of defamation is that what is published or the imputations that derive from what is published are false. Privileged. So absolute privilege. So anything that's said in court is absolutely privileged. Qualified privilege.
So you can say anything you want about anyone in court, even in answer to a question?
Generally, yes.
Okay.
Because it's in the court process and the courts want you to be as honest and open as possible to allow them to make the proper decision, then there's no qualification on what you can or can't say. Obviously,
except you're bound by your oath.
Yes, absolutely. You're bound by oath. It must be true, but that's a separate issue.
Sure.
Qualified privilege, which is where you publish to a group of people who have a real interest in receiving the information. That's often very tricky to ascertain who has a real interest, but it's usually when, say, for example, in a corporate situation, board members will often have an interest in hearing about what's happening within a particular company.
So even if it's defamatory, you can tell the board about things that have happened in the company because they have a genuine, proper interest in knowing that.
It's more than likely that the publication to the board would not... Well, there'd be a defence of qualified privilege to any defamation that was contained in what was published to the board.
And in that example we were talking about just before, where there was an allegation between two school teachers of sexual harassment, the principal had an interest in knowing those allegations.
Correct. I mean, there would be certainly be a defence of qualified privilege by publishing it to the principal, yes. Other ones are honest opinion. It doesn't need to be true, but you only need to convince a judge that your comments were based on an honestly held opinion, in that it was clearly an opinion, it related to a matter of public interest, and it was based on proper material.
So that can be useful for the website publications that we were just talking about. If a solicitor is publishing an opinion piece, but it has to be an honestly, I guess, and reasonably held opinion.
Yes, that's right, and that's why it's very useful to quote your sources always. But this defence can be defeated if it's not an honestly held opinion.
Okay.
I mean, obviously that's very difficult to say whether someone's being honest or dishonest, but that's the issue with defamation. It's always a very fluid thing. Innocent dissemination, as I discussed earlier, not only relates to solicitors acting on instructions, but mistaken publications.
Right.
For example, if you unintentionally publish something and you retract it immediately, you're likely to have a defence of innocent dissemination. Limitation defence, there's only 1 year within which to bring a claim for defamation from the date of publication. And the reason for that is that this is about reputational harm. It's unlikely that a year down the track anyone is going to really remember or pay much attention to what was said in a publication that was made a year ago. So it needs to be very urgent. Apologies, as I said before, you can make, in an offer to make amends, you can include an apology. Separately, though, if you do make an apology at any time, the courts, they don't use it. It's not strictly a defence, but it's a mitigation argument. As before, if you can take the sting out of a defamatory imputation by apologising, then the court will say, well, reputationally, your damages are very limited. And triviality, which is where the circumstances of the publication were such that the aggrieved person is unlikely to have suffered any harm whatsoever.
So just on that defence of triviality, I want to talk about a case that I think is particularly interesting, the 2014 decision of Stanton and Fell. And the reason I think it's interesting is because it turns on what was said, the context in which it was said, and who it was said to, and what that person already knows about the circumstances. So Stanton and Fell is a case actually about doctors. It's about the vascular surgery department of Wollongong Hospital, which in 2010, 2011 was going through a bit of a political time. There was some conflict inside that department, and some of the trainee doctors had been upset by that conflict. And so the Board of Vascular Surgery decided to disaccredit the hospital from training doctors. And the hospital objected to that, asked for it to be reconsidered. And when writing back and reaccrediting the hospital, it is alleged that the Board of Vascular Surgery defamed one of the doctors inside Wollongong Hospital. I'll tell you the names of the three doctors because there are only three of them there. There was Dr. Huber, the head of department, Dr. Stanton, the plaintiff, and Dr. Villalba. And what the Board of Vascular Surgery wrote, a very innocuous email that said, "We understand the conflict has been dealt with. Please reassure us that all training will happen by either Dr. Huber or Dr. Villalba." They didn't actually name Dr. Stanton at all, but that's the alleged defamation. Was Dr. Stanton said by not being named in the email, there was an implication that he was incompetent to train trainees. And in the decision initially in the district court and then later in the Court of Appeal, the court held, first of all, that there wasn't that imputation. There could have been any number of reasons why the Board of Vascular Surgery didn't want Dr. Stanton training trainees. But also, more importantly, the email was only sent to the head of department. It was sent to Dr. Huber. And the court held Dr. Huber, he was in the department. He knew Dr. Stanton. He worked with him all the time. In fact, the conflict was between those two doctors. So by writing anything about Dr. Stanton to Dr. Huber, the Board of Vascular Surgery was unlikely to change Dr. Huber's own view, and it couldn't really harm Dr. Stanton's reputation because Dr. Huber had his own views about that person and had already had all this information, so much more than could be affected by the alleged defamation. And so it was held that that was trivial because the damage to reputation was unlikely to be very great. And I think in situations which we are seeing with claims against solicitors, there's often publication to only one other person. So it can really depend on who that person is and what that person already knows about the alleged aggrieved person.
Yeah, that's right. In defamation, you do only need to publish to one person other than the person about whom the statement is made. But it's very much the case that it really does depend on who that other person or other persons are. As you rightly say, in Stanton and Fell, there was already a pre-held view of the doctor by the other doctors, and as such, there's no reputational harm. And defamation is all about reputational harm. Indeed, there's an argument, though, that you shouldn't even proceed in certain cases where the publication is only to a few really irrelevant people. Mm-hmm. In the English courts, they have a concept of proportionality, which is a bit like triviality, but it operates in a different way. Triviality is a defence that a defendant can raise. Proportionality is an issue for the courts themselves, where they say, well, the defamation or the defamatory statement has only been made to a small number of people, and therefore, and those people are of no great consequence. So, and by that I mean they either personally or professionally have no great input into the defamed person's life. So it's an abusive process to bring a claim for defamation where the publication is only to a small and limited amount of people of whom they have no great interest, and to bring a claim would be a waste of the court's time. We don't really have that in Australia, although a couple of recent New South Wales cases have suggested that it might be coming in. There was a case against Yahoo, and the publication was found only to have been read by 2 or 3 people, and the court stayed the proceedings on the basis that it was just a waste of the court's time to proceed, because they couldn't demonstrate that these people were of any consequence to the aggrieved person, and therefore it would be a drain on the court's resources to proceed.
There are other implications though as well, aren't there, in terms of damages you're likely to recover? If you've only published to one person and that person didn't think much of you anyway, how much are you likely to get in damages?
Very little, because reputational damage is the real key issue of defamation claims. And if you can't demonstrate that your reputation has been damaged, then why are you entitled to any award of damages? So it's very clear that even if you get past the threshold, any threshold of proportionality, the defence of triviality will arise, and you can't get any damages. I mean, there are three heads of damages you can get in defamation. One is general damages, and that's damage to your reputation. The other one is aggravated damages, which is where a defendant runs his or her defence in a way that causes aggravation to the reputational harm that's already been incurred. And the third is special damages, which are basically economic loss damages. Right. Now, if you can't demonstrate that you've suffered any great reputational damage, then your general damages are likely to be low or nil. Aggravated damages will follow suit. Yeah. Special damages unlikely to arise then, because if
you haven't damaged your reputation.
Absolutely. If you haven't damaged your reputation and you can't demonstrate that you've suffered any economic loss, and it's unlikely where you haven't actually suffered any reputational damage, then you're going to get either no damages or very minimal damages.
So that brings me to a cause that's close to my heart, which is defamation claims brought by one solicitor against another solicitor. And we see this quite often. And I think it's counterproductive on both sides. So we see a number of claims where solicitors write to each other, usually initially about their client's case, and then pretty quickly it escalates into allegations against the other solicitor. You shouldn't speak to me like that. You're not a very professional person. You're handling this badly. And it just seems to become more then about the solicitor, the other solicitor, than it is about the client's case. And all that has to happen in those circumstances is for one other person to be CC'd on the email chain, and then suddenly you've got a defamation action. But I don't think it's a particularly helpful or useful tool to have to bring a defamation claim against your opponent in litigation, because you seem to then lose any sort of objectivity that you were bringing to the original proceedings.
Oh, I mean, that's right. I mean, it must be said that a solicitor has as much right as anybody else to bring a claim for defamation against another person, even if that other person is a solicitor. However, what people go to solicitors for really is for their objectivity, their thick skin and their ability to fight a case for them. If in circumstances where, yes, on a daily basis we do have very heated discussions with our opponents, that's just the nature of the job. But if you get drawn into a personal fight, what this shows is, firstly, you're not being objective. You can't see the wood for the trees, as it were, in that you're not progressing your client's interests. You might be wasting time and money in either defending or pressing a claim or some allegation of injured reputation, where that's got nothing to do with your client's case. It can be a distraction, it can cause delay, and that's not what your client came to you for.
So how do we take the heat out of that argument?
Well, I think there's one very easy way, and that is if you do get an email or a letter that you feel contains some rather sharp allegations, the best thing to do really is to pick up the phone, call the solicitor who sent you that letter and say, look, I've got your letter. It's what you've said about me is incorrect, and also I find it quite offensive. Can we please just stick to dealing with our clients' respective interests? And it may well be that you can put your client's interests forcefully, but it doesn't need to get personal. I mean, we have obligations under the solicitor's rules to be honest and courteous with everybody else in our profession, including our opponents, I think an easy way is just to call up, because if you respond in writing, often it can cause an escalation. And then what we were talking about earlier, the distraction, the removal of the client's interest from the correspondence can happen very readily. And then you just get involved in this trench warfare where you're throwing grenades at each other. And both of the client's cases are sort of disappearing off into the ether. Another issue, though, is that reputationally, as a solicitor, do you want to be seen as a person who is thin-skinned, easily riled? Not really. I mean, that's not what our clients come to us for.
No,
Is
we're supposed to be objective, reasonable, dispassionate.
Absolutely, and be able to go into battle for them with their interests squarely in our sights.
Sure.
The flip side to that also is that amongst the profession, if you are someone who is seen to be easily offended, so that you will write emails saying, I've been offended, or you will write sharp emails and become personal, people won't really want to deal with you. And a lot of our job involves a need for collaboration, even with your opponents, to get things done. And people will avoid you. Clients will start to avoid you as well. It's just in nobody's interest, particularly as solicitors, to get involved in such personal accusations.
So another kind of allegation, solicitor on solicitor defamation allegation that we see, it seems to me, is driven by issues other than the defamation itself. So I'll just give you an example of a case. Again, this is an unreported decision, but we had an allegation where there were two neighbours in a neighbourhood dispute, people in an apartment building, and the upstairs neighbours were alleged to have been making too much noise, and the downstairs neighbour got a solicitor to write to the upstairs neighbour asking them to please keep the noise down and actually asking them to put carpet on their floors. And the upstairs neighbour was a solicitor and didn't allege defamation against his neighbour, alleged defamation against the neighbour's solicitor. Wrote and said, I want you to retract that letter. You've defamed me. I've had all of this loss to my reputation. It seemed to me that that was a very thin defamation argument, and that the real purpose of writing that letter was not because that solicitor felt that his reputation had been damaged, but was for a collateral purpose. So what are the dangers in bringing defamation allegations for a collateral purpose?
Well, defamation is increasingly seen in both Australia and around the world as a specialist area, and that's because there are strict requirements on how to plead out a defamation claim and how to defend a defamation claim. It's often been said that there's no greater minefield in pleadings than in defamation, and that's because of the significant amount of process involved in the early stages of defamation claims and the strict requirements enshrined in various court rules as to how to plead and particularise defamation claims. And in any defamation claim, at an early stage, you will have a number of interlocutory applications for strikeout of pleadings, and that will be either by a defendant seeking to strike out certain aspects of the plaintiff's case, or the plaintiff seeking to strike out certain aspects of a defence. And this is really where the real energy comes in a defamation claim at an early stage. So if you are seeking to bring a claim for a collateral purpose, either your opponent or a judge will see it very early on. If there's nothing behind your allegations, it will be found out.
So I guess to wrap it up, the message that we have for solicitors is that if there is an allegation that a solicitor has defamed someone in the course of giving legal advice, then Law Cover is here to defend you in those circumstances. But maybe think really carefully about whether you want to make those kinds of allegations against one of your fellow practitioners, because there's very little to be gained from bringing defamation claims against fellow practitioners, and it just wastes everybody's time and money.
Yes, look, I certainly agree with that. I mean, as solicitors, we are supposed to be dispassionate, objective, and pressing the interest of our clients. Always think about that when you're involving yourself in a heated argument with a fellow solicitor. If you feel it's getting too heated, step back, phone up the other solicitor and try to resolve it then. But at all times, on both sides, think about your reputation. Your reputation as a solicitor is all we have. You want to be seen as being someone who can deal with these small little fractious arguments and just kill them and move forward. So in short, step back and think about what you really want to do, and your reputation is key.
Thank you very much for joining me today, Alex.
No problem. Thanks, Alyssa.
Thanks for listening to Risk on Air by Law Cover. Join us for the next episode and subscribe to stay up to date.